Welcome to the ninth and final part of my free YouTube course about franchise law in Ontario. As we wrap up this course about Ontario's Arthur Wishart Act, otherwise known as the Franchise Disclosure Act, in this video, you'll finish off your knowledge of the legislation with some comparatively simpler sections that won't take too much to explain. Many of the remaining sections have been repealed, so they are no longer part of the law, and I'll let you know which sections have been repealed. Starting off with Section 9, this section says that the rights given by the Arthur Wishart Act are extra. They do not take away from or replace any other legal rights a franchisee or franchisor might already have under other laws. In simple terms, if you're a franchisee or franchisor and you have a right to sue or take legal action under this act, then you can still also rely on other laws that give you protection or allow you to take action. This act adds to your rights. It doesn't cancel out or reduce any other legal options you might have. So, for example, if a franchisee has a claim under this act because of bad disclosure, but also has a valid claim under general contract law or consumer protection law, they can pursue both. Section 9 makes it clear that using one set of rights doesn't block you from using others. Moving on to Section 10, this section says that if a franchise agreement tries to apply the law of a different place instead of Ontario law, or tries to force legal disputes to be handled in a court outside of Ontario, that part of the agreement is legally invalid, but only when it comes to claims that fall under this act. In simple terms, even if a franchisor includes a clause in the contract saying that disputes must be handled in, say, Florida, or that Florida law applies, that clause won't work if the dispute involves rights under Ontario's Arthur Wishart Act. Ontario law still applies, and the case can still be brought in an Ontario court. This protects franchisees in Ontario by making sure franchisors can't use contract language to take away their right to rely on Ontario law and Ontario courts. It keeps the legal process fair and local for franchisees operating in the province. Next, Section 11 says that a franchisee cannot give up or waive their rights under the Arthur Wishart Act even if they sign something that says they do. If a franchisor or franchisor's associate tries to get a franchisee to agree, on paper or otherwise, to give up any of the protections or rights the Act gives them, that part of the agreement is legally invalid. In simple terms, even if a franchisee signs a contract that says something like, "I won't sue you for failing to give me a disclosure document," or "I agree not to rely on the protections of the Act," that clause has no legal effect. The law steps in and says, no, you can't waive these rights, they are built in and can't be signed away. This rule protects franchisees by preventing franchisors from pressuring or tricking them into giving up legal protections, especially in situations where there's a power imbalance. The rights and obligations in the Act are mandatory and can't be avoided, no matter what the contract says. Moving on to Section 12, this section says that if someone, usually the franchisor, is trying to argue that they don't have to follow a certain rule in the Arthur Wishart Act because they fall under an exemption or exclusion, it's up to them to prove it. They must provide the evidence to show why the rule doesn't apply to them. In simple terms, the default assumption is that the rules in the Act apply. If a franchisor claims, for example, that they didn't have to give a disclosure document because of an exception in the law, they have to prove that the exception really applies. The franchisee doesn't have to prove that the franchisor should have followed the rule. The franchisor must prove they were legally allowed not to. This section protects franchisees by making sure franchisors can't simply say, "We didn't have to do that," without backing it up. The burden is on the franchisor to justify any claim that they're not subject to the usual legal obligations. Subsection 1 of Section 13 has been repealed, so we'll skip that one. Subsection 2 of Section 13 says that if a franchisor meets certain conditions set out in the regulations, the Ontario government can make a regulation that allows that franchisor to leave out certain financial information from the disclosure document. This exemption would only apply if the franchisor qualifies under the criteria and follows the rules set out in the exemption. The exception is pretty long, and I'll include a link to it in the description. However, briefly, a franchisor can be exempt from providing certain financial information if they have either at least $5 million in net worth or at least $1 million if they're owned by a parent company with at least $5 million. On top of that, the franchisor or its parent company must have at least 25 franchisees actively doing business, either in Canada or in another country. They also need to have been in business for at least 5 years, and neither the franchisor nor its key people can have been found guilty of fraud or unfair practices in that time. The financial statements that support these claims must follow proper accounting and auditing standards, like those from CPA Canada or international boards, depending on where the business is based. However, this exemption isn't permanent. If the franchisor no longer meets the financial or business history requirements, or if they or their key people are found guilty of fraud or deceptive practices, the exemption is canceled. At that point, the franchisor would once again need to include full financial disclosures in the document. Subsection 3 of Section 13 says that any regulation made under this part of the Arthur Wishart Act, such as one that grants a financial disclosure exemption, can apply broadly to many franchisors or narrowly to specific ones. In other words, the government can create rules that apply to all franchisors who meet the criteria or just to certain types of franchisors or industries. Subsection 4 of Section 13 explains that an exemption can be taken away if the franchisor no longer qualifies under the rules, or if the franchisor asks for the exemption to be removed. So even if a franchisor was initially granted an exemption, they can lose it if their financial or business situation changes, or they can voluntarily give it up. Subsection 5 of Section 13 states that decisions made under this section, such as granting, refusing, changing, or canceling an exemption, don't have to follow the procedures set out in the Statutory Powers Procedure Act. That act normally ensures fairness in administrative decisions, but here, the government doesn't have to hold hearings or follow formal legal procedures when deciding whether to grant or revoke an exemption. This makes the process faster and more flexible for the government. Subsections 6 and 7 were repealed, so we're going to skip those. Section 14 gives the Ontario government, through the Lieutenant Governor and Council, the power to make detailed rules, called regulations, to support and clarify how the Arthur Wishart Act works in practice. In simple terms, this section allows the government to fill in the blanks by setting specific requirements and definitions that aren't spelled out directly in the Act. For example, they can define what a cooperative association means, set dollar amounts for certain thresholds, list what types of business changes count as material changes, and describe exactly what must be included in disclosure documents and statements of material change. The government can also decide how documents must be delivered, for example, by email or in person, what kinds of financial statements are required, what percentage of sales matters in certain calculations, and what day a rescission notice counts as being received. They can even define terms that aren't already clearly defined in the Act and make additional rules on anything they think is necessary to make sure the law is working as intended. Overall, this section gives the government flexibility to update and enforce the law through regulations without needing to rewrite the entire Act every time something needs to be changed or clarified. Subsection 2 of Section 14 says that any regulation made under Subsection 1 of Section 14 can apply either broadly to all franchisors and franchisees or narrowly to specific types, situations, or industries. In simple terms, the government can make a rule that applies to everyone covered by the Act, or it can make a rule that only applies in certain cases, for example, only to franchisors in the food industry, or only to franchise agreements over a certain dollar amount. This gives the government flexibility to tailor rules as needed. Sections 15 and 16 are no longer valid, so we'll skip those. Congratulations! You've completed this free YouTube course about franchise law in Ontario. By working through each video in this series, you've gained a clear understanding of the key legal rights, responsibilities, and protections that apply to franchisors and franchisees in Ontario. Whether you're entering a franchise relationship, advising others, or simply building your knowledge of franchise law, you now have the tools to recognize red flags, understand disclosure obligations, and protect your interests. Remember, this act was designed to promote fairness and transparency in the franchise industry. The more you understand it, the better equipped you are to navigate that world with confidence. Thank you for taking the time to invest in your legal literacy. Stay sharp, stay informed, and good luck on your journey ahead.